Buenas tardes y
Good
gracias.
afternoon, and thank you for continuing to attend this important 2021 virtual conference for immigrant integration. Next, we will begin the panel of the review of immigration policy. Before we begin the panel, let's take a short historical tour of some immigration policies. Let's look at the beginning, because in the same way that the Declaration of Independence affirmed equality for all, the reality is that historically the United States has limited citizenship and immigration based on race, gender, and class. The Nationality Act of 1790 was the first law to establish rules and procedures by which immigrants became US citizens by naturalization, but it limited this important right to free white people. In 1868, the 14th Amendment was ratified to ensure equal treatment for African Americans and citizenship for all persons born in the United States. It also provided equal protections and due process for all legal residents. In 1907, the Expatriation Act removed citizenship from women born in the United States when they married non-citizen immigrant men. This was reestablished under the Immigration Act of 1922. In 1924, the Indian Citizenship Act stipulated that all Native Americans born in the United States were automatically citizens by birth. In 1965, the Immigration and Nationality Act established the fundamental principles for the regulation of immigration. A system of preferences for family reunification, employment, and refugees was applied. In 1986, the Immigration Control and Reform Act addressed unauthorized immigration, providing amnesty for established residents and increased border control. In 1996, the Illegal Immigration Reform and Immigrant Responsibility Act, it further empowered federal authorities to enforce immigration restrictions. In 2012, Deferred Action for Childhood Arrivals (DACA) protected from deportation and gave work authorization to people who arrived as minors, better known as the Dreamers. From 2017 to 2020, under President Trump's administration, they issued a torrent of orders that reduced refugee admissions, limited eligibility for asylum, made it more difficult to approve permanent residency or citizenship. In 2021, President Joe Biden has reversed some of the measures and he has promised integrated and integral immigration reform. Below, lawyers and academics, experts in immigration law will delve into this topic. This panel will be moderated by Ileana Montes, Director of the Legal Department of IACO.
Good afternoon, everyone. It is such a great pleasure to be here with you, with the great group of panelists that are joining us today, and to be able to give this conference to the immigrant community of New Jersey. But obviously, because we're doing it virtual, we are also very happy that people from other states are joining us. And I'm very, very confident that this information we are about to hear from our experts is going to be of great interest and also of great importance to all of you. So I want to give all of you the welcome and special thanks for joining us today. I want to tell you a little bit about myself. My name is Ileana Montes. I'm the director of the legal department at organization, IACO. IACO has been in existence since 1999, and we provide direct services, immigration services to the community. Over the course of the years, we have served different communities, including individuals from 150 different countries. One of our purposes and our goals is to assist the immigrant community in the integration process in the United States. So we are extremely happy to be the hosts of this conference. And, not only we're going to be talking about immigration policies and immigration laws, but throughout the course of the day that you're going to see that you're going to have opportunities to hear about other issues that are of great importance to our immigration community. So let me just tell you that it is really important that this year is the 50th anniversary of the landmark law that rewrote the U.S. immigration policy. Today, we have nearly 59 million immigrants that have arrived into the United States, and that is pushing the country's foreign-born share to nearly 14%. And that is extremely important because obviously when we talk about immigration and immigration laws, there is a huge segment of the United States population that gets affected. Over the last administration, we saw many changes in federal policies since January of 2017 that have targeted millions of immigrants for deportation by ending or limiting avenues to legal status, separating children from their asylum seeker parents at the border, barring people from certain majority Muslim countries, slashing the number of refugees admitted to the United States, and in many instances, forcing asylum seekers to remain in Mexico while they apply for protection. So we are going to be talking today a little bit about what had happened during the last administration, what are the hopes during this administration, what are the policy changes that have transpired during these very few months, and where do we go from now? We know that our community has been desperate for an immigration reform. We know that there are some bills that are pending, and obviously all of us here as advocates for immigration hope to see some changes, positive changes during this administration, perhaps in a reform, but if not, at least in separate bills so that we can better protect our very, very vulnerable population. Today, I am so excited to have 4 panelists that are extremely experienced in the issues of immigration. They are going to be talking about some of the hot topics that we are facing today. Obviously, the immigration law is so extensive that we cannot cover absolutely everything, but they are going to give us an overview as to where we stand in reference to DACA, for instance, in reference to the public charge and inadmissibility. I'm gonna be asking some questions at the end regarding political asylum and TPS, which is temporary protective status for certain countries. So we have a lot to talk about. So first of all, I like to welcome Ana González Barrera. Ana González Barrera is a senior researcher at Pew Research Center. She is an expert on U.S. immigration, particularly on Mexican immigration to the United States and border apprehensions and deportations. She also has extensive experience analyzing and surveying the Hispanic population in the United States. Before joining Pew Research Center in 2011, she served as the Director of Population Distribution at the Mexican Population Council. Prior to that, she worked for over 4 years at an institute in CIDE, which is called CIDE in Mexico, where she coordinated 2 rounds of the Mexico and Americans Public Opinion Survey in 2004 and 2010. She received an MPP from the Harris School of Public Policy Studies at the University of Chicago, where she was a Fulbright Garcia Robles Scholar. Anna, thank you so much. I know that you're going to be talking today about key factors about the U.S. immigration policies and specifically about President Biden's proposed changes. So having said that, I welcome you and I give you the floor.
Thank you very much, Ileana, and thank you to Jaco for the invitation. I'm very happy to be here with you. I'm going to share my screen so that you can see the presentation that I prepared.
Absolutely.
Let me just make sure that we are on. So can you see the presentation?
Yes, we can.
Okay, perfect. So my presentation is somewhat short, so I hope I won't go over the time allotted to my presentation. So I'll just go over some key facts about U.S. immigration policies, some of the proposed changes by the Biden administration, and also some of the results that we have seen in our surveys of public opinion in the U.S. So first of all, the Biden administration is acting on a number of fronts to reverse the Trump-era restrictions on immigration to the United States. The steps that the administration is taking includes plans to boost refugee admissions, to preserve deportation relief for unauthorized immigrants who came to the U.S. as children, and not enforcing the public charge rule that denies green cards to immigrants who might use public benefits like Medicaid, some of which is going to be spoken about later in the panel. So in this first slide, I'm showing the number of people who received a green card during the latest year in 2020. This is through the third quarter of fiscal 2020. And we can see the sharp decline in the number of green cards that were allotted. So green cards were slightly being reduced year by year, as you can see, mostly through backlogs and other things. But during the pandemic, the decline was just totally dramatic. Already some of these restrictions have been lifted by President Joe Biden, and we already see that in the third quarter of the 2020 fiscal year, so from the 2019 to the 2020, there was a dramatic shift, and we don't have the data for the 2021 fiscal year yet, but we are assuming that some of these numbers will go up because now the offices of USCIS are open. But I don't have the latest data to show that to you yet. We do know that the administration proposed some of changes to streamline the receipt of these green cards. And so the proposal is to increase the number of visas that are being allocated. Most of the green cards that are given in the US every year, and this is data again from fiscal 2019, we're not focusing on 2020 because it was such a different and unusual year. So in 2019, there was more than 1 million visas given during the year. Or actually, no, it was 710,000, sorry. I correct myself. 710,000 lawful permanent residents were given. 710,000 were given through family sponsorship, and this made up about 7 in 10 of all the green cards that were given through family sponsorship. Some of the proposals that are given have been done by the Biden administration is to increase the number of green cards given, mostly by reducing the backlog of the family-sponsored visas, also increasing the ceiling for refugees, and increasing some of the employment-based immigration visas, and also the diversity program. So all of these slices that you see in the pie, there has been proposals that were submitted to Congress to increase basically all of this to increase legal immigration into the US. In terms of refugees, we saw in 2020 a dramatic decrease in the number of refugees that were admitting into the US. Already the ceiling had been dropping during the Trump administration, but we saw in 2020 because of the pandemic that it basically went to a very, very low level, not seen before. Originally, when the administration started, they had proposed to raise the ceiling to pre-pandemic levels. However, very early on, or about a month ago, they actually decided to keep the 18,000 ceiling from the Trump administration because the pandemic was still around, and they were highly criticized for this. So they raised the ceiling of refugees, but they are still quite slow in processing all of these cases. So some of the other slices that I showed earlier are the employment-based green cards. So some of these, there are also proposals to increase the number of visas that are given through this way. But also, for example, in the case of H-1Bs, there were some restrictions that were put on by the Trump administration. The Biden administration is trying to review all of those to figure out if there's a way to streamline and increase the number of people with higher education that can obtain and come to work in the US. The other type was the diversity visa program. This is a program that has actually for a long time been a target for elimination. There has been some conversations about getting rid of it, but the Biden administration, what they proposed earlier in their administration was actually to increase the number of diversity visas in the program rather than eliminate it. Next, we see what is the H-1B, that is the employment, or more like all the employment visas. So that's what we see in this chart. And we see that one of the largest numbers comes from H-1B. This is high-skilled workers and also agricultural workers. And these numbers had also been declining, particularly H-1Bs, because of some restrictions that the Trump administration put in place, and some reviews and other things that made it a little bit more difficult for people to obtain these H-1B visas. But the H-2A visa actually was not as affected, and on the opposite, there was some increase in these numbers during the Trump administration. All of these programs, particularly H-1B program, is being targeted for an increase under the current administration. And finally, I had mentioned at the beginning that there are some temporary permissions for unauthorized immigrants, or what we at Pew consider unauthorized immigrants. One of them is TPS, the temporary protected status, that is estimated to cover more than 600,000 immigrants from 12 different nations. So this was another program that was a target of restrictions during the Trump administration. And the Biden administration is reviewing some of these and overturning some of the expiration dates that were set. We already saw some countries being added and others having an expiration date being expanded. So this is a program that affects particularly big numbers of Salvadorans and currently Venezuelans as well. Venezuelans are currently the largest number of holders. It happened very recently that they were added into the list of beneficiaries. And traditionally, El Salvador has been the country that has benefited and depends on this program the most. The other program is the Deferred Action for Childhood Arrivals. So about 640,000 people who were once youth immigrants to the US have received this temporary reprieve from deportation. In this map, I show you more or less the distribution of the largest 25 metropolitan areas that have received or where DACA recipients reside. So as you can see, California has particularly gotten a lot of these. And when we have looked at the demographics of some of the recipients, we also see that Mexican immigrants are the most likely to have benefited from the program. So this is a program that has gained always a lot of sympathy from the public and also from politicians. There is a proposal to move the people who have benefited from the program to a legalization. This will be part of a bigger package where not only people with DACA would benefit from it, but also all the people that we estimate are here without authorization in the US. Our latest estimate is that of 10.5 million immigrants living in the US without authorization. So now I'm just going to mention some of the results that we have from our surveys of public opinion. So for example, half of Republicans say that there should not be a path for undocumented immigrants to stay in the US, whereas among Democrats, the large majority say this. And we've actually seen a decline in the support among Republicans for legalization of unauthorized immigrants. This actually goes a little bit against when you see at these numbers in the overall, you don't see a lot of movement. The overall share of people, the large majority, say that they should be allowed to stay and have a way to stay in the U.S. legally. But we have seen that the sympathy has dwindled quite a bit in the last 5 years among Republican voters particularly. When we look at how the US public feels about immigration overall, we see that overall the majority of Americans think or view immigrants as a strength for the country. And this is a view that has completely flipped in the last 20 years or so since we started doing this question in the US. However, there is a big political polarization here as well. So Republicans are the less likely to see immigrants as a strength to the country, and they're more likely to say that they are a burden to the country instead. When we ask the US public about the priorities for the border, we see that people are more likely to support increasing staffing and resources available to patrol and police at the border, and also including the staffing and resources to process unaccompanied children more quickly at the border, together with reducing the number of people coming to the US to seek asylum. There's not a lot of support for allowing people to seek asylum in the US, and also providing more assistance to countries in places like Central America, or there is not so much support also for making it harder for asylum seekers to be granted legal status in the US. So some of these more restrictionist policies are a little bit less popular, but also the ones that are more likely to support the origin countries of some of the flow that we're seeing at the border, and that we will see as maybe more supportive of immigration are not as popular as well. When asked if they think that the U.S. government is doing a good job in the U.S. at the U.S.-Mexico border, we see that most people say it's not being handled well. But there is a big difference between political parties and when we ask this question. So when Trump was around, Republicans were more likely to favor the policies that were being done at the border. And now with the Biden administration, at the very beginning of the Biden administration, we saw that the Democrats were more likely to support the job that the president is doing at the border, even though most of them still disapprove of what's being done at the border. And overall, for the US public, we know that dealing with immigration is not a top priority. It's among the bottom tier It's much more important to strengthen the economy, to deal with the coronavirus outbreak, to improve the job situation, other things. Also, when we asked about some of these particular policies that the Biden administration has proposed, most Americans support granting legal status to immigrants who were brought to the U.S. as children. So this is paraphrasing what DACA means. So we see a huge amount of support, even among Republicans. Majority of them support granting them legal status. And we also see large support for those who are undocumented to be allowed to stay here legally. And again, we see a huge partisan divide here. When Democrats, 89% of them say they favor this, and Republicans being more divided between immigrants not being allowed to stay here legally and also allowing them to have a way for legalization if they meet certain requirements. And that's the end of my presentation. Let me know if you have any questions. You can find all of these findings in our website. Thank you so much.
Thank you so much, Anna. Very, very interesting statistics and numbers to understand the public view, to understand the differences between the parties, the political parties, of course. Let me just ask you a quick question, because obviously you mentioned that the public view has changed and now is more favorable towards immigration and legalizing the undocumented that it was years ago. Do you think that now that we had the coronavirus outbreak, that public view perhaps may change over the short term?
You mean if the coronavirus outbreak has had any effect in the public's view?
In the public support for legalization of immigrants?
We have not seen a huge shift, and this might be because the number of immigrants coming during the coronavirus outbreak is very small. Even at the border, we're seeing an increased number of apprehensions of people trying to cross illegally, but they are not huge numbers. So mostly what media is focusing on is the unaccompanied children at the border, and we have not explored attitudes towards them in our surveys yet, but I would expect that if we were to analyze some of these, we might find some kind of change in their views about how to handle the things at the border. We have not explored them yet. Particularly about unaccompanied children. We know that children bring a lot of sympathy to the minds of the public in the U.S. So people tend to be a lot more sympathetic to them, but they might not be as sympathetic to their parents, for example. So that is something that we have seen in the past. We haven't explored it yet. We would have to see how that works during the pandemic, or how that would show up during the pandemic.
Perfect. Thank you so much. And, you also mentioned about DACA and, how both parties, including Republicans, tend to be in favor of legalizing the young adults that came to the United States. Nevertheless, in the last 2 years, DACA, we went through a roller coaster of decisions going back and forth as to whether DACA was going to survive. I'm happy to say that, thank God, according to the last court decision, the terms of DACA went back to their initial terms. So, the USCIS is accepting initial applications, is accepting advanced parole applications, and also extending the work authorization that initially in the last administration they wanted to restrict from 1 year to 2 years. So I'm happy to see that. Anna, thank you very much. I'm sure that we're going to have many more questions for you. But we're going to move on to our next panelist. And I'm extremely honored to have with us Professor Lori Nissel. I'm actually very excited because I graduated from Seton Hall Law School. So in addition to having the pleasure of introducing her, it really brings me great memories of the center and obviously of the law school. Professor Lori Nessel's teachings and scholarship focuses largely in the areas of immigration and refugee law and policy, international human rights, rule of law, and access to justice. She is a professor of law and served as the director of the Seton Hall Law School Center for Social Justice for 14 years. She now directs the Immigrant Rights International Human Rights Clinic and oversees the law school's component of the statewide Detention and Deportation Defense Initiative. Professor Nessel regularly teaches immigration and naturalization law and the Immigrants' Rights International Human Rights Clinic. She has also taught international human rights law, gender and the law, selected topics in immigration law, and advanced comparative issues in refugee law. She came to Seton Hall Law School in 1995 after completing a Skadden Arps Public Interest Law Fellowship representing migrants farm workers in upstate New York and working as at the small civil rights firm in New York City. In her Human Rights and International Human Rights Clinic, Professor Nessel supervises live cases and human rights fact-finding and advocacy projects, including claims under the Refugee and Torture Convention, as well as cases involving human trafficking, family reunification, and other forms of relief from deportation. She is currently supervising students in human rights project examining private deportations of immigrants by hospitals in the United States. Professor, it's indeed a great pleasure to have you. You're going to be sharing your expertise and your knowledge about political asylum and particularly the policy changes that we have seen recently. Thank you. The floor is all yours.
Great. Thank you so much. Thank you, Ileana, and to everyone that worked to put this amazing multi-day conference together. So important. And thank you very much for including me. Right. So I'm going to talk, as you said, focusing in particularly on asylum and sort of where we're at in terms of policy and some of the changes taking place. But in order to do that, definitely have to kind of start by taking sort of a huge leap back, because obviously I want to talk about some of what went on during the prior administration. But even just to start for a moment, going all the way back, I think it's important for us to think about, I mean, the International Human Rights Convention that is at the heart of asylum, the way our asylum process works, right? The Refugee Convention. It was drafted in 1951, or the drafting was completed in 1951. The US didn't actually sign on to it until 1968. Then in 1980, Congress implemented our domestic law, the Refugee Act. But going back to 1951 for just a moment, I think what's really important to keep in mind is that the drafters of the Refugee Convention, again, our core document, they had a very particular sort of prototypical asylum seeker or refugee in mind that was worthy of protection. And that was basically, this is post World War II. The Refugee Convention was very much drafted with an eye kind of looking back. It wasn't a forward-looking document. It was about looking back at World War II and at the US and other nations' complete failure to protect all of the refugees that were fleeing from the Nazis. And that absolute failure to protect people in a worldwide basis was the impetus that got countries to come together and draft the Refugee Convention. And so actually, when the convention was first drafted, it had both geographic and temporal limitations written right into it. So it was very clear who was to be protected. It was, someone who was fleeing particular events that occurred before a particular time in the 1950s in Eastern Europe. Some of those particularities were taken out. But the reason that I wanted to start all the way back just for a moment is because I think part of what we've been seeing even before the Trump administration, what we've been seeing for many, many years is, really a narrowing of protection for asylum seekers in this country, and largely because the people that need our protection now look very different than as initially envisioned by the drafters, right? So if there was, the prototypical refugee was a white, probably Eastern European male who risked his life to stand up and take a pro-democracy position. And of course now, the biggest groups of people that are coming here seeking protection, at least in our area, I mean, they tend to be people from Central America, are a lot of them. People are fleeing gang-based violence, domestic violence, violence on account of their sexual orientation. So it's very, very different. And so I just wanted to start with that because, when former President Trump took office, we already had a lot of narrowing and restrictions in terms of who would be protected with asylum. But of course, that said, what we saw during the Trump administration was, came very, very close. Like I really think I'm not exaggerating in saying he brought us to the precipice of eviscerating asylum protection across the board. I mean, and as horrific as I think that was, it's sort of mind-boggling in terms of how many different fronts it took place on, right? How much was done to completely destroy protection. And again, I want to get into this a little bit because I think that we need to understand that to then say, where are we now? And what has President Biden done? And what do we need going forward? So for example, during just 4 years of the Trump administration, his administration issued more than 400 executive orders on immigration. There were more than 1,000 policy changes made to the immigration regime overall. There were at least 96 asylum-related policies. Again, that's an incredible amount. And so almost on a daily basis, things were changing and always with an eye, without exception, towards narrowing protection for asylum seekers. And so this happened in a number of different ways. In terms of the law, what we saw during the Trump administration was an unprecedented number of attorney general decisions that were aimed at narrowing the law and making it virtually impossible for many of our current day refugees to be protected. So people that are fleeing gang-based violence, domestic violence, gender-based violence. And when I say it was unprecedented, that's because the Attorney General has always had the power to take a decision from the highest, the Board of Immigration Appeals is the highest administrative tribunal for immigration, for asylum decisions. And the power exists for an Attorney General to take a decision, certify it from the Board of Immigration Appeals to his or herself, and then reverse it. But it's largely existed on paper, theoretically. It's been very, very rarely used in the past. During the Trump administration, the attorney generals at one point it was daily. And there were just constant decisions that the attorney general was going down saying, don't like this one. Let's reverse it. And so just the actual law was being narrowed in an incredible way. Another huge thing that was happening was limiting, if not trying to completely cut off just access to asylum protection in this country, particularly at the southern border. And so this happened in so many ways that I can't even in a limited amount of time go over all of them. But basically the idea was, in my opinion, that what the administration was trying to do was make it so that those who needed protection remained outside of our country and outside of our vision. Because the more that people are invisible, the less rights they have, the less the public cares or knows. And so it's much easier to take away due process rights, protection, guarantees to be able to seek asylum under international human rights agreements, under our domestic law. It's much easier to do that if it's done where no one sees, people don't know. That's, on the other hand, that's why so many people are detained. I think it also makes it much easier within the country to take away rights when people are locked up and, again, outside of sight. So in terms of the southern border, they're all these programs are incredibly misnamed, because they have names, each one, that connotes justice, mercy, expeditious processing, and none of it, well, maybe the expeditious processing, but the others certainly aren't true. So there's the Migrant Protection Program, had absolutely nothing to do with protecting migrants or protecting anyone. Most people don't even refer to it, the Migrant Protection Protocols, most people refer to that as the Remain in Mexico program, because that much more accurately depicts what it was. And so, again, just quickly, that meant that for a huge number of people that were seeking protection that came up from Central America largely, and came through Mexico, they were told, okay, you got to wait in Mexico until we can process you. You're not going to be allowed in to wait in the US, remain in Mexico. And to some people that aren't familiar with the program, I think that, again, that might not sound that bad if you didn't know anything about it. But it had, life and death and just horrific consequences for the people that were put into the Migrant Protection Program, because they were forced to wait, not in Mexico generally, but in the most dangerous parts of Mexico, because people had to be close enough to the border that when and if they got notice that they now had a hearing, they had to be able to get to the border and wait all night to be admitted in for that hearing. So they were forced to remain in extraordinarily dangerous conditions. And they were also, the US would return people the same time, the same days, to the same spots, which made them prey for kidnappers, for drug cartels, for gangs. And so the deaths and rapes and kidnappings, it's been well documented and is absolutely horrible in terms of what happened. Then, of course, with COVID, the entire program was suspended. So these people that were already traumatized and vulnerable then had to wait. So people waited for over a year, waited for very long times, try and move more quickly. There were many more programs like that. Again, in the interest of time, I won't get into all of them, but there was a whole web of programs so that an officer at the border could choose which one he or she wanted to use, but to keep people from even accessing protection. Other things that happened: incredible expansion of expedited removal, meaning a procedure so that there's much less due process, things move much more quickly, and then, of course, sweeping overhaul of our asylum regulations that, thankfully, federal courts played a very big role during the Trump administration in stopping, whether temporarily or permanently, many of the worst provisions of this administration. So the Biden administration, come to 2021, the Biden administration inherited an asylum regime that was, virtually decimated, eviscerated. And so right away, the Biden administration has done some really, really positive things in terms of asylum. There was a executive order that he issued, a very, very broad executive order entitled "Creating a Comprehensive Regional Framework to Address the Causes of Immigration, to Manage Migration through North and Central America, and to provide safe and orderly processing of asylum seekers at the US border." And that does a combination of some of the worst programs were withdrawn. Some of them, there was a direction to the Department of Homeland Security secretary to review them and with a certain amount of time to review them and see what else could be done in their place. But it also aims to create a comprehensive regional framework to try to get at the root causes of migration. So Biden administration did outright end that migrant protection protocol, the Remain in Mexico. So that is over. Also ended a couple of those other programs that, for lack of time, I haven't gotten into, but that were also at the southern border. Now, those people that were in the migrant protection program that are still alive and that are still in Mexico many of them are being paroled into the country. We represent some of them here in New Jersey because they're now able to finally come into the country and seek asylum protection. The Biden administration has also revoked a Trump memo that made it much harder for asylum seekers to obtain employment authorization. Biden administration has established priorities for detention, increased the refugee cap from 15,000 to 62,500, and many other programs that have not yet been ended, but where at least the Secretary of Department of Homeland Security has been told that it's time to review these programs and report. Oftentimes there's been a 180-day period put in place for the administration to come up with something else. In terms of some of the problems that still exist, and we do still have, I think, a long way to go when it comes to asylum. Our law is still really bad. Those decisions from the Attorney General that make it so difficult to seek protection are still in place. So I think that's a big question, is what, if anything, will be done to actually change the law. One of the executive orders from President Biden did order a 180-day review of asylum eligibility for victims of domestic violence and gang violence. So we're still within that window. And so I think that immigration lawyers and advocates are hopeful that we'll see some positive change, again, so that the law opens up more and people will have their fair chance to seek protection. The regulations was over 400-page document of asylum regulations that were meant to gut asylum under the Trump administration. It's always been referred to as the death to asylum rule. And so that was enjoined by a federal court in California. But again, we're still waiting to see what the Biden administration will do in terms of a permanent solution and revoking those. So let's see, there are, if it's okay to take a couple more minutes.
Yes, absolutely. Yes.
Oh, okay, great. So in terms of some of the problems that remain right now, and again, I don't want to understate that I think it's a much, much more positive moment for asylum seekers, certainly than the past 4 years. So I'm thrilled with the changes that have taken place. There are still things that really need to change, though. One of them is that the Trump administration had put in place a program for expulsions that take place under the public health law. So it's Title 42 of the public health law. It's not an immigration law, but it does allow, in the case of a public health emergency, it authorizes, it's basically closing the border and not letting people into the country, which in this case includes even people that should have a right under our domestic law and international human rights conventions that we've ratified. There's a right to seek asylum. There's not a right to be granted asylum, but there is definitely a right to seek asylum. So the Trump administration started doing what are referred to as expulsions, which are what they sound like, right? No chance to even ask for asylum. You're just pushed back from our southern border. Sadly, the Biden administration has kept that in place, and it's happening all the time. And so we are still in a situation where desperate refugees at our southern border are being pushed back without even having an opportunity to seek protection. And then the other thing is that, our overall asylum and immigration regime has been criminalized over the years, and this certainly goes back before the Trump administration, but has been criminalized to such an extent that there really is a need to decriminalize, because we see the connection where, of course, that was part of what was being used by the Trump administration to justify separating families at the border. It was, and of course, the horrible jailing of children. It was that, well, but the parents are criminals if they're trying to cross the border. And so there are much deeper changes that need to take place. The only other thing in terms, and I think it's fine if I don't get into this, I was asked to discuss trafficking visas for victims of human trafficking, but that's an area we could talk about it later if there are questions, but there really aren't as many policy changes to discuss. Have been what's been really hard in that area is more the way that the immigration agency has taken a required much more evidence. We've seen this sort of across the board, denied many more cases, made it much harder as a matter of practice for people to seek the visas that exist for victims of human trafficking. And so there is a need for change there. But again, I don't want to talk for too long. So happy to address that more later if there's time and interest. Thank you so much.
Professor, thank you so much. Indeed, what we witnessed in the last administration with the 96 asylum-related policies was indeed atrocious and, of tremendous consequences for the families. I mean, we kept seeing the news and hearing from our clients that children were being separated from the political asylum parents. Have all the children been reunited with those political asylum parents? And for the ones that have been reunited, I know that this is a two-part question, but for those that have been reunited, has there been a program to help them deal with the trauma of separation?
Yeah, it's a really good question. The first part, sadly, is easy to answer because the answer is no. I mean, there's much more effort being made now, for sure, to track down the parents and reunite them with the children. There have been a number that have been reunited now, but it's very hard to find people. So there are certainly still families that are separated and haven't yet been reunited. In terms of the second part of the question, yeah, the trauma is incredible because even for, like I say, the progress that's being made now with finding the parents and bringing them back together. I mean, I'm a mother of 3. I can't even begin to imagine what that trauma is like when a family is separated for that long, and the sort of trauma on both sides. And, obviously a lot more needs to be done once they're reunited. I'm not completely sure what sort of programs are in place for dealing with the kind of mental health needs that have to exist, because what I've seen has been much more focused on sort of the efforts between the administration and the courts, and some of the amazing work that the ACLU and others have been doing to just get that step one, getting them back together.
Yeah, it's really is a very sad situation when you add to the fact that they're political asylum seekers because of the persecution that they were experiencing. So they come with a drama, with a trauma, with a hope of getting help and getting, their lives together and getting safety for their children, and they encounter this additional trauma to their lives. So it's really, really devastating. Thank you so much. We're going to move on. At the end, we're going to have some additional questions about political asylum, and hopefully we can get a few questions about human trafficking. I know that we're not going to be able to go in depth into that topic, but being that is such a high organized crime nowadays, and I believe it's the 3rd ranking organized crime in the nation that it deserves at least a little bit of attention. And hopefully down the line, we will do a seminar specifically on human trafficking. But thank you, Professor. I really appreciate it. We are going to move on. Next, we have attorney Cesar Martinez Stella. Cesar was born in Lima, Peru, and moved to Mexico as a child. He understands the very unique situation that immigrants find themselves navigating through the legal system. He has handled hundreds of immigration cases while working in his previous law firm. He ensures that each client is given personal attention and satisfied that his case is being handled thoroughly and competently. Attorney Stella was raised in Newark. He attended elementary school and high school in Newark, and he graduated very top in his class. He graduated magna cum laude from Seton Hall University with a Bachelor's of Arts in Philosophy and English and a minor in Classical Studies. He then graduated also cum laude from Seton Hall University School of Law. His unique cultural and educational background permits him to provide honest and creative solutions for his client's case. He is also the president of the New Jersey chapter of the American Immigration Lawyers Association. And I am very happy to have you here, Cesar. I have known Cesar also through the Hispanic Bar Association of New Jersey. He is an often panelist at immigration seminars, not only in New Jersey, but nationwide. So I welcome you. Cesar is going to talk briefly about removal defenses and inadmissibility. Thank you, Cesar.
Hi, I'm Cesar Estella, and thank you, Eliana. Just let me know in my time, because I can talk about this,
Absolutely.
all afternoon.
Yes.
So I have some PDFs I can definitely share, and I'll get to them, but I'll explain now what we're going to talk about. Specifically, we're talking about removal and detention. And the things go hand in hand, unfortunately, in the United States. They don't have to, right? Immigration is a civil violation, but we have a huge private detention industry built around immigration violations. And so there's a big push to end private detention. The Biden administration has, in fact, through budgeting, I think, are trying to end increased budgeting for detention, but has made a carve out for private immigration detention facilities. And so there's, in New Jersey, there was a State Bill 3361 that is moving forward to disallow the state from entering into future contracts with ICE. And as of May 6th or May, no, I might be wrong. First week of May, ICE is no longer detaining new individuals in New Jersey. If someone is detained, they are moving them out of state. We don't really know where. The balance of ending detention in your state is there's 49 other states that might, well, maybe not 49, but some red states that might want that money, and then they'll be detained down there. With the advent of video technology, these individuals will be far removed from their families and have their hearings done remotely via video for the most part. So that's a key, something that's happening now. It's probably going to play out over the next during his administration. But there hasn't been anything that I can point to that makes me think that they're going to end civil detention in the United States. It's too much business, unfortunately. The business of incarcerating brown and black people in America is a story for another day. But what we were looking at in the detention world is in New Jersey, we're going to have a whole new paradigm. As an immigration lawyer, a lot of attorneys are looking at this and thinking, well, what happens to my practice if I'm dealing with detained individuals who are being moved out? I know the law clinic has defended some detained individuals. I know I have detained a number of detained individuals. So that changes the consideration if I have to, as an attorney, contact my client and then the family's here in New Jersey, but the client's down in Georgia, and coordinating a medical, something as easy as coordinating a medical for someone who's eligible for their green card while detained. I know which doctors to call in New Jersey. I have not a clue which one's going to drive 6 hours to Lumpkin, Georgia detention facility to do immigration medical. And so something as simple as that is kind of like the delays that are cooked into the sauce that then prejudice and harm this immigrant's right to qualify for relief. So when we think about the prior administration, it's intentional delays, right? The cruelty was the point when you're talking about using parents crossing as the justification for separating them from their children. That's obscene. You wouldn't do that to puppies, but we're doing it to human kids, right? So when you look at the prior administration, the delays were intentional. USCIS experienced something like 100% delays, even though they had a 10% decrease in filings. And there was systematic obstacles that were created, and Professor Nerschel touched on this with asylum, but on a whole, at the USCIS agency, right? So one of the things that doesn't touch on removal, but it does indirectly, because a lot of people who are in removal are fighting their case. We rely on USCIS to have timely adjudications that we can then present to the court and the judge as attorneys. So it's very frustrating when one agency is intentionally delaying and the other agency is running at Hussein Bolt's pace to try to quickly get someone a deportation order. Because if the point is to give them a deportation order and not due process, then the court ceases to function as a court. It functions as an enforcement arm. And that's the issue, the tension that's always existed within the immigration court, right? In 1983, it was under the INS, the immigration court was under INS, and then they moved it under the Department of Justice to give it a semblance of independence, so as to say, of course, the Department of Justice would never be politicized. We never had 3 attorney generals in as many years. But immigration court was moved into the Department of Justice to give it that independence and not be part of the enforcement branch. So there's a huge, there's a very targeted approach that's been moving forward for many years, but seeking to make immigration courts Article I courts. And I don't know what that's going to play out this year or next year, but it is going to play out. I'm very hopeful that by changing the immigration court from taking it out of the DOJ and putting it on the level of a Veterans Affairs Court or a Social Security Administration Court, an agency court, it'll give them more funding, and it'll give them the independence they need to operate at a court as a court, providing due process, even though it's minimal due process to these aliens who just want to stay with their families, right? Sure, there's a criminal in there, right? But for one guy, you're gonna kill or you're gonna exile 100. That's obscene. The system has to work better. The detention aspect of it right now in New Jersey, the way we're seeing it play out is what I just mentioned. The removal side, it's tricky. I have there was a lot of lawsuits targeting a lot of the changes that the Trump administration made in the immigration courts. A lot of them were playing out during the election. There was a change in regulation, and there was a lot of changes that the Trump administration pushed through in the last 120 days of their reign to modify the immigration court and how it functioned. The one that gave me the biggest headache in December. So it was published November 30th, went into effect December 2nd, and it gave the immigration judge the authority to cancel hearings and issue an order saying everything is due by this date, right? But it didn't give any time or accommodation to let attorneys prepare and say, okay, starting March 1st. No, it went to effect December 2nd, PM 2105. And that created havoc and headaches for countless immigration attorneys nationwide. We were coming together to sue the immigration court to enjoin that, but we didn't need to. The Biden administration came in, and April 2nd, they issued a formal pause. They rescinded the policy memo. So that's one change I can point to that was done within the first 30 days. The other thing was there's a new EOIR director, Gene King. And now that Merrick Garland was confirmed at the end of May, we're hopeful, and we're hearing from the Roundtable of Immigration Judges, we're hearing from AILA National, AILA is the Immigration Lawyer Association of New Jersey, we're hearing from them, and we're hearing from our own channels that we're going to expect to see some changes. So one of the big changes we're seeing is they rolled out a new tool called ECAS. And ECAS is an online tool where you can check and file things electronically, which would then go hand in hand with a more efficient court system to remove a lot of the unnecessary physical requirement that aliens have to go to the federal building to present for their initial hearing. There's 2 different types of hearings. There's an initial hearing and a final hearing. A lot of the things could be taken care of more efficiently on the papers by filing online. I would prefer it. My client doesn't lose a day of work. The immigration staff is top notch. They're hardworking staff. they can clear, filings that are done correctly relatively quickly. You'll get your final court date. Then you can give me a scheduling order, and now everybody you can actually work with the system you have to make it more efficient. That was announced February 4th that it was going to be rolled out. Newark Immigration Court is now in that program as of May 18th. But it's only dealing with any new case moving forward, right? So it's always, you take one step back, one step forward, two steps back, because there's a million plus cases in backlog that we would not be able to clear up because they didn't plan to integrate the current existing cases. So when we're talking about the significant changes that we're seeing in the removal proceedings now, one that I pointed to was a policy memo that was enacted back in November, PM 2105. But there was other changes that were seeking to end the ability to reopen a deportation in the interest of justice. That was doing away with the power of an immigration judge to administratively close a case. Let's say I'm sponsoring my wife. I'm a resident. There's a little delay. I'm telling the judge, listen, Your Honor, I know I have court today, but I've already sponsored my wife. It's about a year wait before she can go get her visa. And so don't deport my wife. Just pause this temporarily while we resolve something with another agency. That would be an efficient use of court resources. They were doing away with the judge's authority to do that by regulation. So it was regulation enacted December 1st to go into effect January 15th. And that regulation was enjoined by the courts, right? There was another change that had to do with, and these are more court or legislative changes, that had to do with whether someone is now eligible to for what's known as cancellation of removal. There was a Supreme Court decision in 2018, Pereira v. Sessions, that specifically dealt with the initiating document. What starts a deportation for anybody is you get a piece of paper called an NTA. And if that piece of paper it has to comply with the law. The law was written, right? And so it says exactly the law tells them what they need to put on it. But because it was very difficult for the ICE officers doing the arrest and starting a deportation to know the court hearing availability date, they were not completing the charging document correctly. So the Supreme Court said, well, if it's not completed correctly, then it doesn't trigger what's known as the stop time rule. So now we're getting in a little bit into the weeds. But what the stop time rule says is if you're issued one of these charging documents, your time in the United States is legally stopped. You cannot say, I've been here before the judge. I can't go and say, my client's been here 30 years. If he got one of those charging documents when he came in at the border, he's only been here 3 days. So you can have all the equities in the world, but that would prevent him from qualifying for certain relief. This change in the law was invented in 1997. It didn't exist before. And we can talk about the 1997 law. A lot of the problems we're seeing stem from that law: unlawful presence bars, delays in petition, like people or DACA or younger citizens not being able to sponsor their parents. The 1997 law, IRA, did cause a lot of pain, and is currently causing a lot of pain to immigrant families in the United States. But that specific change, where it said if you're issued a deportation document, you can't show the judge, you can't tell the judge, I've been here this long. You've only been here a few days, or a few weeks, or whatever it is. And for certain green card applications before the immigration court, you have to be here at least 10 years. So the courts have recently decided, and I mean very recently decided, I think it was April 29th, that if the document, the charging document, the NTA is not issued correctly, because ICE didn't fill it out correctly, then it would not be able to prevent someone from qualifying and showing the judge, I've been here this many years. And that opens up eligibility for people to fight for a case in the United States that they might not have been eligible to do before that Supreme Court decision. And those types of changes are what we're seeing, right? But those are the consequences of lawsuits filed against the former administration, in particular, the decision that came out May 5th out of the court, the Third Circuit Court of Philadelphia, that deals specifically with our district in Newark, that if and is affirmed by the Supreme Court decision I just described. So all these changes, again, were attorneys like me filing appeals and motions back in 2018, 2017, 2019, getting them up to the courts, and then in this case, I know the attorney who's handling that case, or the attorneys who handled that case. and preserving those rights for that gentleman. So now he can go back to the judge and say, "Oh, I want my case closed," or "Oh, I want to qualify for cancellation or removal." And these are very real applications that people can now have in court to stay here and remain with their families. Because ultimately, it's really just about that, keeping families together. What else did we talk about? And I don't have anything else to say if anyone has any questions.
Thank you, Cesar. Thank you so much. And what you first mentioned about that New Jersey is not going to be housing any more immigration detainees is going to have a serious impact on the attorney-client preparation, because while we will have access to talking to the clients via Zoom and whatnot, we all know that it's not as effective as having that one-on-one conversation. There is always that apprehension by the person that is detained that perhaps the conversation is being recorded or that somebody else is hearing. And it's never the same. I mean, we have seen in other aspects now through the COVID-19 where the hearings take place via Zoom, and it's just you lose so much of the preparation and the testimony of the client, and also is it gonna delay the individual hearings? Are the people really going to be produced when the individual hearings come in? So that remains to be seen, but it's definitely problematic. Thank you so much, Cesar. We will definitely have more questions for you. I want to move on now with our Mark Parry. Mark Parry is an immigration attorney, but also he serves on the board of our organization. He has been in private practice since 1986. His office is located in Bloomfield, New Jersey. He obtained his bachelor's degree from Yale University and his law degree from the University of Pennsylvania. He has been a member of the American Immigration Lawyers Association for over 30 years. Mr. Parry has been a lecturer and speaker at immigration law conferences and seminars sponsored by the Federal Bar Association, the Institute for Continuing Legal Education, numerous educational institutions, as well as nonprofit and private organizations. He has served on the Supreme Court of New Jersey Ethics Committee for Essex County, and he was the chairperson of the New Jersey Immigration Policy Network Legal Committee for 15 years. He served in that capacity as a volunteer basis. He is a well-respected and experienced immigration attorney, having served on several nonprofit organizations providing immigration services to the public, in addition to his pro bono work for over 30 years. Today, Mark is going to talk to us about family-based petitions and also when it's necessary to apply for waivers in cases when people are not eligible for adjustment of status in the United States. Thank you, Mark. Welcome.
Thank you for the invitation. There are a number of categories in family sponsorship, and I wanted to describe that first. A U.S. citizen can file a petition for a spouse, a mother or father, or an unmarried child who is under 21. That's called the immediate relative category, and it does not have any limitation on a yearly basis like some of the other categories. In addition to the immediate relative categories, we have what are called preference petitions. And we have the first preference. Those are U.S. citizens sponsoring their unmarried sons and daughters. We have the second preference A, which are the petitions by permanent residents for their spouses or for their minor children. We have the family preference 2B. Those are the unmarried sons and daughters of permanent residents. We have the third preference, which are the married sons and daughters of U.S. citizens. And then we have the fourth preference, and that involves siblings sponsoring who are U.S. citizens filing for their siblings. Now, the main difference between what are called immediate relative petitions and the preference categories is that the preference categories are controlled by quotas. There's a limit on the number of visas per category, and the quota is fashioned depending on the category and also per country. So some countries have a longer wait for visa availability than others. And generally speaking, if someone is in one of the preference categories and they are here in the United States and they're here unlawfully, then they won't be able to finish out their process here in the United States. They would have to go outside of the country to finish it. Now, processing through family sponsorship is a two-step process. The first step involves filing an immigrant visa petition, which is a Form I-130. And the second step can be one of two. It can be an adjustment of status, which is a process where you file additional paperwork with your immigrant visa, and you can finish your petition processing here in the United States with an interview process. That's called adjustment of status. And historically, the people who were eligible to adjust status were the children of US citizens, and by children, under 21 unmarried, the spouses of US citizens, and also the mothers and fathers of US citizens, if those people entered the United States with inspection. With inspection means that you came into the country with a visa, a non-immigrant visa, could be a tourist visa, a student visa, a work visa, and it really didn't matter whether or not you overstayed the visa, but you had to be coming into the country with an inspection, or you had to have been paroled into the United States. A parole is a permission by the US government to come into the country. Sometimes they're given for humanitarian reasons, or if someone has a medical condition and they need to come for certain medical assistance and help and oversight, they will issue a parole. We also have more recently a parole in place process, which is something that's available to family members of people who are serving in the US military. There's a process for people who are already here in the United States that they can obtain a parole in place. And if they do get an approval on a parole in place, they can then file for adjustment of status if they have the family relationship that I described earlier with a US citizen. Now, anyone in the preference categories usually will not be able to adjust status in the United States if they're here, with the exception of whether or not they've maintained lawful status for each and every day that they're here in the United States. So now I want to give you a little bit of a history on immigration law and some of the legislation that's affected family sponsorship over the years. If someone had come into the United States crossing the border prior to 1994, they would never have been able to finish their process here with an adjustment of status, the interview process here. They would have to have filed their immigrant visa petition, the I-130. It would be approved by what was then the Immigration and Naturalization Service. Now it's known as USCIS. And with that approval, the case would be transferred to the National Visa Center in the state of New Hampshire, where a number of forms and documents and information would be processed so that this way an appointment could be set up with the US consulate in the home country of that person. The person would travel a couple of weeks in advance of that interview, have their medical taken in their home country, be fingerprinted, go to their interview, and if everything was in order, they would be issued an immigrant visa in their passport, and they would be given a sealed envelope to then return to the United States and present at the airport. And at the airport, after the inspection, a stamp of permanent residence would be given to them. And that worked very well for many people in the family preference categories and even in the immediate categories if they weren't eligible to adjust status. What happened then was in 1994, a piece of legislation was passed. It's known as 245 small letter I. Section 245 in the Immigration and Nationality Act has to do with adjustment of status. And Congress at that time added an additional paragraph, making it possible for people who would not be able to do their interview process here, not to be able to adjust status here in the United States, gave them the option of paying additional money to the US government, filing an additional form, which is the I-485A supplement, and being interviewed here and not having to go outside of the country to finish their processing for their status. Many people availed themselves of this, and the law expired in January the 14th of 1998. The reason it expired was that it was not passed as permanent legislation. It was passed as a temporary measure. And that law was not extended until December the 20th, 2000, and for a short window until April the 30th of 2001. There is a slight difference between the first version and the second version, because the second version of the law requires that the person who is going to avail themselves of 245I under the second version, they have to have been present in the United States prior to December the 21st of 2000. Since April the 30th of 2001, that law is expired. And so that means that anyone filing a petition now by family, if they cross the border, they entered without inspection, or if they fall into one of the categories in the preference system, then and they don't have lawful presence here in the United States for every single day that they've been present physically, they will not be able to do a process here. Now, one of the other measures that drastically changed the immigration practice when it comes to family sponsorship was a measure that was passed in 1996. Cesar mentioned earlier some drastic immigration laws that were passed that had a terrible effect in many ways. Well, this is one of the very bad ways that it affected processing of immigrant visas and getting permanent residence. It's known as the 3-year, 10-year bar provision, and it was passed in the 1996 legislation. And in essence, what it says is that if someone has 6 months unlawful presence in the United States physically, or more than 1 year, and that's after April the 1st of 1997, and that person physically leaves the United States, and it doesn't matter why they're leaving the United States, they will trigger off a bar. That means that they won't be able to come back for either a 3-year period if their presence here was 6 months or longer, but less than a year. But if they've been here a year or longer illegally, and they leave the country, the bar is 10 years. There was also a waiver written into this process, and the waiver is available only if you have a relationship with a lawful permanent resident or U.S. citizen spouse, or a mother or father who's a resident or a spouse. It cannot be based on children. So in essence, what happened after this law was passed and after 245I expired, people who only had the option of doing the consular process outside of the United States, many hesitated to do this because it was not a guarantee that the waiver would be processed. And what you had to do was you had to file your immigrant visa petition, get it approved preliminarily by the Immigration Service, and then it would be passed on to the National Visa Center. You would work everything up so this way your appointment would be set up to go out of the United States. You would have to leave the United States, trigger the bar, either a 3-year or a 10-year bar. And then what would happen is you'd have to ask for your discretionary waiver while you're already outside barred. And if it was denied, that meant that you had to stay out for those 3 years or 10 years. It was a very severe measure. So a lot of people found themselves boxed into the United States. They could no longer file adjustment of status if 245I was not available. And then they also did not want to take this risk because it was a pretty serious risk. If you were here for more than a year, especially, you'd be out of the country for 10 years if your waiver wasn't approved. And what we were seeing was that I think it was around maybe 50% were being approved and 50% were being denied. So many people found themselves kind of boxed into the United States and they didn't want to do anything one way or the other. In 2012, President Obama passed an amended regulation. It's known as a regulation that created the I-601A waiver, and it also created a regional office that would accept this processing. And it's known as the provisional waiver to try to get the forgiveness that you would need if you have to do the consular processing out of the United States. And what happens now is you file your family petition, it's approved, it gets passed on then to the National Visa Center. The fee for the immigrant visa is paid along with the fee for the affidavit of support. And then you alert them to the fact that you're filing an I-601A waiver for the provisional waiver that you will need for when you go outside of the United States and trigger off the bar against you, the 3-year bar or the 10-year bar. So that this way then, if it's processed in advance of you leaving the United States, if it's not denied, then you know that you can finish your process, you can go outside of the United States, and you have the peace of mind of knowing that you'll be able to come back. If it's not approved, then you would not continue the process because there would be no sense in that. You'd find yourself then stuck outside the United States. So this is definitely something that's been used now very much in family petitions. And in 2014, it was expanded to include the spouses of permanent residents in addition to the spouses of citizens, and also sons and daughters of US citizens and permanent residents can also process these provisional waivers in advance. Now, it should be made clear that this provisional waiver, the I-601A, only forgives unlawful presence bars. That means the bars that stop you from being able to come back because of your unlawful presence here in combination with a physical departure from the United States. Now, after the first version in 2012 with the second version, they opened it up and they said that if you have a deportation against you, you can first file an I-212 waiver to have your deportation bar waived. And if you're successful, then you can file your I-601A waiver in addition to the I-212. And you would then go to your consular process with both waivers in hand that you would need. And many people are now availing themselves of that as well, because it has become, if you don't have adjustment of status available to you and you have a deportation order, you have to then get both waivers approved in order to be able to get your immigrant visa and come back to the United States relatively quickly. Now, as I said to you, this waiver, the I-601A, does not cover any other problems that would cause you to be barred from the United States. So for instance, if you have a history of criminal convictions, you cannot avail yourself of the I-601A waiver. If you have a history of immigration fraud, you cannot avail yourself of the I-601A waiver. You won't be able to do it. You're not going to be able to get your status without with that process because it's not going to be available to you. Just trying to think. That's primarily how people are doing it now. It's with the I-601A waiver if they're not eligible to adjust status. That's about it. There's not too much more that I can think of in addition to what I've said. There are more things technically, but I don't think it would be more appropriate for attorneys than for the general public.
Thank you so much, Mark. And obviously, we know that the consular process takes a long time, not only because we have to wait for the visa to be ready, but
Right.
now with the coronavirus, can you give us a little bit of an update? Are the embassies, the US embassies, all open? Are they doing this type of consular processes?
Yeah, during the COVID period, we've had just about all the consulates were not processing cases. I'm not 100% sure whether or not any have already started processing. The last time that I looked into it a little while back, I didn't see that any were. I know that all of our cases are still kind of in a holding pattern. We have filed the paperwork with the National Visa Center, and we're waiting to hear on scheduling, but we have not had any cases scheduled thus far. I should also point out that with respect to the preference categories, I'm not sure if when I said about the quota system, I wanted to give a little more clarity to it. The system is set up that depending on who the petitioner is, if it's a citizen or a permanent resident, who the beneficiary is, that category will get more or less visas allocated in a given year. And so that will determine then what the time frame is going to be for the issuance of an immigrant visa. And the way that you mark the place in time in the waiting line is with the actual filing of the petition, and the date that it's filed becomes known as the priority date. And every month, the U.S. State Department publishes a visa bulletin, and that bulletin will specify what priority dates are now current, meaning for what type of a petition is the immigrant visa now available. And that's how you will then know whether or not you're coming close to being able to finalize your case.
Thank you so much, Mark. Thank you, all of you, for the presentation. This is such an valuable information for our community. I do have a couple of questions. Anna, I wanted to ask you, because you mentioned that in the case of DACA, Mexicans young adults are the ones that have benefited the most. Have they benefited the most because the Mexican population is the largest, or because there is a discrepancy between the immigrant community as to who is applying more? Can you clarify that?
Sure, definitely. So you are touching two reasons why they have been the largest group to benefit. So both are true. One, they are the largest number. They make up the largest number of unauthorized immigrants, also among those who would qualify for DACA. But we have also seen that Mexican immigrants were more likely to apply for this benefit and were more successful. A lot of these can be because of where they were located and how much support they received for the process. So some of them received financial support from Mexican government, from the consulates and the embassy. They were actually giving some of the fees, paying some of the fees for them to process these. They were also having a lot of informational fairs and other things to help them with the process and helping them with some law clinics and etc. for applications, but also some local governments were facilitating these applications as well. So I think all of these things really help young Mexican immigrants to process these cases. I don't think they were necessarily more likely to succeed in their request, but they were more likely to submit a request to begin with.
Interesting. Thank you so much. Professor, in terms of the political asylum applications, can you just very briefly, I know that we can go on and on this, but can you very briefly discuss the difference between the affirmative claims versus the defensive claims?
Sure. So in terms of, it's the same application that's used, the IPAB 89, to apply for asylum, whether affirmatively or defensively. For many people, there isn't any choice, though. So what happens is basically, if someone is already in removal proceedings, whether they're detained or not, if they're already before a judge, then they're going to apply for asylum defensively, meaning in immigration court. If someone is, let's say, for example, someone came into the country, whether they came on a visa and overstayed or were able to get into the country undetected, if someone is not yet in removal proceedings, then they can apply affirmatively. When you apply affirmatively, it's the same law that applies, it's the same application, but it goes forward before an asylum officer rather than going through the immigration court system.
Thank you. And how much time do the applicants, let's say it's an affirmative, somebody who has come to the United States is not in removal proceedings, how much time do they have to submit that application?
So there's a 1-year deadline, although one of the things, correct me, anyone, if I'm wrong, but so there's a 1-year deadline. The reason I'm saying correct me if I'm wrong is because part of Trump's new asylum regulations was going to cut that way down to, I think, 2 weeks. There was a much shorter period, but that hasn't gone into effect. So there is 1 year to seek asylum.
Okay, perfect. Thank you so much. Cesar, you were mentioning about the discretionary motion to close proceedings. That is definitely a good tool, effective for the court when people are waiting for petitions and they're just waiting for the process specifically before USCIS. But is that motion also available for people that do not have petitions pending? Let's say a father of a US child, but that child is not 21 yet. Would that person be eligible to apply for that discretionary motion to close proceedings?
No, but that's the short answer to your question. But the correct answer is the discretion to close proceedings for someone who doesn't have some sort of relief would be contingent on the prosecutors agreeing to say, you know what, we're gonna close it. And we did that before. This existed before during the Obama administration. It was known as prosecutorial discretion, and the prosecutors would see a case like the one I had, Peruvian guy overstayed his visa. His kid wasn't a citizen yet. You just, something similar, and they administratively closed it. Right now, his kid, we're waiting for them to reopen his case so that he can now apply for his green card. And now we're dealing with the delays in the immigration court, which is a different headache, but they did exist. So the correct answer to your question is currently DHS issued a nationwide email of sorts saying we're going to present new priorities. Mayorkas is reviewing them, and he is going to announce these new tools that the prosecutors would have so that the immigration judge can say, well, if the prosecutor agrees and the attorney agrees, I don't have an issue. Get this case off my docket. Get this case off my calendar. So that would be something additional that is in the pipeline, but I couldn't tell you what.
Thank you. Thank you. And Mark, I have a final question for you. You mentioned that the unlawful presence provisional waiver obviously only waives the, for lack of redundancy, the unlawful presence. But what happens if a person goes to his or her country, goes before the embassy, and then is asked to provide another waiver because of fraud or other issues of inadmissibility? Can you expand a little bit upon that?
Well, if they have a qualifying family member, they can process a waiver while they're outside of the United States. However, if it's an immigration fraud bar that they're facing, that can only be waived with the relationship with a U.S. spouse or permanent resident spouse or a mother or father who's a permanent resident or U.S. citizen. It cannot be based on children. Also, if they have a criminal conviction, they can base it on the same family members, in addition to also children who are citizens or residents. If I could mention a couple of things very quickly, I think are important. If you're eligible for adjustment of status and you have any of these issues concerning criminal convictions or immigration fraud, and you have the appropriate family members to support the waiver, you can file that in connection with your adjustment of status process. And if those waivers are approved, then you can get your permanent residence. And another thing that's very, very important that many people are completely unaware of. In 1996, when they passed those terrible provisions, they added in a couple of provisions there specifically for people who multiple times came back and forth across the border and had more than 1 year of physical presence altogether in the United States at some point after going back and forth across the border. And this has to do with the 96 provision and the unlawful presence here after that. Those people will not be able to process any petition unless they are going to first be physically out of the United States for a 10-year period, in which case then they can ask for the appropriate waiver that would apply to their situation. And then what I'm talking about, it primarily is consular processing. The mistake that's made sometimes is that people don't disclose this, and they've been here before once or twice. They've left the country on an airplane, and it's pretty easy for the government to see that they were here before, and then they can piece it together and see how long they've been here. And if they're captured by that provision, they might have the I-601A waiver approved because the regional office didn't realize that they had been here already in the past and had come back and forth. And they'll go to their interview. And if the consulate doesn't catch it, I've actually had a situation where someone came to me after their family member was caught at the airport coming back with their immigrant visa, and they caught it there. And that person then was expeditiously removed, deported. They were accused of fraud for not having disclosed it, and they also had the 10-year bar because of the unlawful presence. So when the family came to me, we had to process all three of those waivers, and that person is still out of the country a number of years waiting for a decision on those waivers. Also, if you have had a deportation order against you or a removal order, and you physically, after April 1st, 1997, come back into the United States, crossing the border, you will also be captured by that same provision. And that requires you to be physically out of the country for 10 years before you can ask for a discretionary waiver. So that's very, very important. So if you have any kinds of histories like that, you should definitely seek out consultation from a immigration law professional.
Absolutely. That's extremely important for people to really know what the consequences of whatever impediment they have had in the past, to make sure that they're well assessed and we're well represented, so that they don't, go out of the country and then find out that they're not able to come back. I do have one final question. Unfortunately, we have run out of time, but this is very pertinent, and I wanted to get your opinion. Do you think that we have come to the time in our history that after so many years of advocacy for an immigration reform, perhaps this administration is the right time and that is finally going to move in Congress? What do you think? I'd like to hear from all of you.
Well, I would. I've been doing this a long time, and I've been very hopeful for that. Obviously, it's been so many years. So I think 1986 was the last time when we had the amnesty provision, and then after that we had 245I in 1994, and then we had what Obama did with the regulations. And other than that, we really haven't had anything that's been on the positive side of helping people who want to process themselves. However, having said that, there's the slimmest and slightest of majorities that the Democrats have right now. It is a 50-50 split in the Senate. And while the vice president can cast a deciding vote, because the filibuster has morphed into what it is now, which it was not a process like this before, where a single senator could simply just make that an issue and require 60 votes in the Senate to pass legislation. I think that unless something is done about the filibuster, we're not going to see anything of a serious reform with this administration. It just won't happen, because I don't see how they would reach 60 votes in the Senate. And it's not that I'm pessimistic. I'm still hoping that they will at least maybe transform the filibuster to what it used to be years ago, which was a much more involved process, and it wasn't a simple process to just kind of throw a wrench into a piece of proposed legislation. So if they can address that, then I think I would be a lot more optimistic.
Interesting. Thank you. Thank you for your input. Does anybody else want to put their 2 cents about what you think about it? Go ahead, Cesar.
No, I do not think that any meaningful immigration reform is going to be enacted legislatively by the current Congress, Senate. I don't think that, like Mark said, the votes aren't there. They're not doing away with the filibuster. They have 49 senators in Manchin from West Virginia. So the only thing is, if the filibuster becomes something meaningful, then perhaps they could marshal enough of opposition to get a law passed. But that doesn't mean that you can't make significant changes in the current immigration policy and immigration practices that would transform what we would want to see done to treat immigrants with
More respect.
Love, charity, respect, anything other than the current system.
Yeah, or at least to, have smaller bills, if not a comprehensive reform, which is very difficult because of the reasons that you both have already mentioned, at least to have some of the policies little by little reversed, so at least we can get to where we were and then start improving from there. I'm hoping that the public opinion, as Anna said, we know that it has improved in the last couple of years. I am confident that it will continue to improve, and that in the long run, it will have an impact on the politicians that make the final decision. Well, I want to thank you. This has been an incredible panel. I know that all of you are extremely busy, but I know that you are also very committed to the immigration community. I thank you for every work and everything that you do in your daily lives to help our community. And we look forward to having you again as a panelist at future events. Thank you very much, and have a wonderful rest of the day.
Agradecemos mucho su
We
participación.
appreciate your participation. Please do not forget to fill in the surveys. Remember that your response is absolutely private, confidential, and we will not compile any personal information. Your suggestions and comments will help us improve for future editions of our event. Thank you very much.